The courtroom buzzed with tension as the nation's eyes turned to one of the most unexpected legal showdowns in recent memory. Elon Musk, tech titan and provocateur, had found himself facing a federal judge notorious for aggressive fines and heavy-handed rulings. The case was sparked by a controversial comment Musk made during a shareholder meeting, where he criticized regulatory overreach and hinted at government corruption influencing tech policies. Almost immediately, Judge Harold Feynman, known in some circles as the Gavel, issued a subpoena citing contempt of court for undermining judicial authority and integrity. Musk's legal team, stunned by the abruptness, claimed the move was less about justice and more about silencing a vocal critic of entrenched power structures. As proceedings began, the judge levied an eye-watering $25 million fine against Musk for supposed violations of a previously settled SEC agreement. Media outlets framed it as the beginning of Musk's legal downfall, but what the judge didn't expect was the firestorm he had just ignited and the level of legal intellect Musk was about to unleash. As reporters scrambled to cover the story, insiders hinted that Musk had prepared an aggressive countersuit weeks earlier, suspecting a trap was being laid. His team, bolstered by top-tier constitutional lawyers and former federal prosecutors, entered the courtroom with boxes of sealed files, suggesting evidence far beyond what the court had anticipated. The judge attempted to assert control early, barking procedural orders and shutting down motions before they were fully presented. Yet Musk, calm and methodical, stood up and respectfully addressed the court himself, requesting to speak directly. Feynman, caught off guard but intrigued, allowed it. Musk began by laying out a timeline of events, cross-referenced with public records, leaked emails, and internal SEC documents that had been lawfully obtained through Freedom of Information Act requests. Every word out of Musk's mouth seemed calculated, backed by meticulous legal precedent. The courtroom fell silent. His accusations implied not only judicial overreach but hinted at coordinated actions between Feynman and certain political operatives attempting to bring down Musk's influence in national policy debates. The defense presented encrypted communications, authenticated by third-party cyber experts, that showed a string of unusual meetings between the judge and known anti-Musk lobbyists. More startling still, Musk's team had uncovered a chain of financial transactions from a shell organization that traced back to Feynman's private trista, suggesting possible bribery or coercion. The judge, visibly rattled, called for a recess. When the court reconvened, the tension was thick enough to cut with a knife. Judge Feynman returned to the bench with a different demeanor, less domineering, more cautious. Musk's legal team resumed their arguments with a new exhibit, a deposition from a former SEC official turned whistleblower who alleged that the original investigation into Musk had been manipulated by third-party interests with political and financial motives. The deposition, recorded under oath, claimed the case had never been about protecting investors, but about punishing a high-profile figure who had repeatedly embarrassed regulatory bodies and questioned their authority. The whistleblower went on to describe internal memos where Musk was referred to by code names, and meeting transcripts revealed that punitive actions against him were pre-discussed before any alleged violations occurred. That deposition sent shockwaves through the courtroom and beyond. Journalists reported live as details emerged that cast serious doubt on the legitimacy of the charges Musk faced. Judge Feynman, visibly sweating now, tried to redirect proceedings, insisting the focus must remain on Musk's alleged contempt. But the damage had already been done. Musk's attorneys then moved to introduce a second bombshell, digital records from a legal tech firm that had been anonymously contracted to develop predictive models on how judges, including Feynman, would rule in future cases involving Musk's companies. The firm's report concluded that Feynman showed a statistically anomalous pattern of disproportionately harsh judgments against Tesla and SpaceX compared to similar cases. That revelation triggered a ripple of whispers through the audience. The prosecution tried to object, but the judge, realizing that dismissing such a document would only add to the appearance of bias, allowed it to be entered into evidence. Elon Musk, never one to hold back when principles were at stake, then addressed the judge directly again, questioning whether America's courts still upheld impartiality or if they had become instruments of political influence. His words weren't just aimed at Feynman, they were directed at the entire judicial system, daring it to look in the mirror. The judge, now visibly shaken, attempted to adjourn the session early, but Musk's lawyers pushed forward, filing a formal motion for judicial misconduct and requesting an immediate investigation by the Judicial Ethics Oversight Commission. Cameras outside the courthouse captured the rare moment of a federal judge being served an ethics inquiry notice. Within minutes, social media exploded, with hashtags like #MuskVersusSystem and #CorruptGavel trending globally. Public opinion began shifting dramatically. Prominent legal scholars, including those previously critical of Musk, began appearing on national news outlets questioning whether a grave miscarriage of justice had been unfolding right under America's nose. That evening, legal pundits debated furiously across primetime networks, trying to decipher the deeper implications of the courtroom clash. Could a billionaire like Elon Musk genuinely be a victim of institutional overreach? The narrative was no longer just about a tech CEO with a controversial reputation. It had morphed into a constitutional memento test of whether due process could withstand the weight of power politics and backdoor manipulation. Behind closed doors, Feynman reportedly consulted with his own legal counsel, realizing the scope of what had just transpired. He was no longer just a judge overseeing a high-profile case, he had become the center of an ethical maelstrom. Meanwhile, Musk's team filed additional motions, each one more damning than the last. One included surveillance footage from a luxury DC hotel, capturing Feynman meeting with lobbyists connected to competitors of Tesla and SpaceX. While the footage alone was circumstantial, the timestamps aligned with key procedural decisions Feynman had made, raising serious red flags. Another motion introduced financial disclosure anomalies in Feynman's public records, suggesting underreported assets and potential kickbacks. The Judicial Oversight Commission announced an emergency review. As a media circus erupted, the case took on a symbolic significance. Protesters began gathering outside the courthouse. Some were Musk supporters, others were legal reform advocates, but all were united by a common demand for transparency and accountability. In court, Feynman attempted to regain control by reprimanding Musk's attorneys for trial by media, but the statement backfired. Critics pointed out the irony of a judge under investigation trying to claim the moral high ground. In response, Musk's counsel presented one final surprise, a confidential memo drafted by a Dodge advisor warning against assigning Feynman to any politically sensitive case due to prior conduct concerns. The memo had never been released to the public but was acquired through a legal loophole in whistleblower protection laws. The judge paused, seemingly lost in thought, as the courtroom watched in stunned silence. Musk, ever composed, folded his arms and waited. It was no longer just a case, it had become a reckoning. The judge called for another recess, but this time, he didn't return. A junior court clerk emerged and announced that proceedings were postponed pending judicial review. The room erupted. Outside, news vans reported the unprecedented twist. Within hours, the Judicial Oversight Commission released a statement confirming they had launched a formal ethics investigation into Judge Harold Feynman, citing substantive and alarming evidence. It was a move rarely taken mid-trial, signaling the gravity of the allegations. As the investigation gained momentum, a parallel narrative began to form, one where Musk wasn't just defending himself, but dismantling an entrenched system that had long operated in the shadows of legal immunity. Over the following days, previously sealed files were made public, under court order, revealing years of questionable rulings by Judge Feynman, many of which had disproportionately targeted emerging tech firms that threatened traditional industrial lobbies. Independent auditors began reviewing dozens of his past cases. Civil rights organizations joined the fray, demanding further review into judges with similar patterns. It became a national movement, a cry for judicial reform echoed from Capitol Hill to Silicon Valley. Musk, however, remained focused. In a rare public address delivered on the courthouse steps, he stated, "This isn't about me, it's about ensuring that justice doesn't get auctioned to the highest bidder." His speech was broadcast live, garnering millions of views within hours. Political leaders, once hesitant to weigh in, now began releasing carefully worded statements supporting judicial transparency. The Senate Judiciary Committee scheduled an emergency hearing on judicial ethics. Meanwhile, Feynman's legal counsel filed a motion to recuse him from the Musk case, citing conflicts of interest under review. The motion was approved. A new judge was appointed, the one with a clean record and no political affiliations. Under fresh review, the contempt charges against Musk were dropped, and the $25 million fine was declared null and void. In its final ruling, the court acknowledged that the initial actions taken against Musk lacked sufficient legal foundation and appeared to have been influenced by external pressures. Musk's legal team, victorious but solemn, announced that they would pursue broader judicial reform initiatives, leveraging public support to advocate for legislative change. In a twist of poetic justice, Judge Funman was placed on administrative leave, pending a full disciplinary hearing. Several other judges connected to similar lobbying networks were also placed under preliminary review. The ripple effects of the Musk case became the subject of documentaries, law school curricula, and even Senate testimonies. Elon Musk didn't just win a legal battle, he forced an entire system to confront its failings. As the dust settled, one thing was clear: no one, not even a federal judge, was above accountability when confronted by truth backed with undeniable evidence and unrelenting resolve. Musk's actions had redefined the role of citizen vigilance in an age of institutional decay, proving that with the right strategy, the system could still be held to its highest ideals. And in doing so, he reminded the world that real power doesn't come from authority, it comes from truth, and the courage to speak it in the face of corruption.